Thank you. You may be seated. So, people, you would like to recall a witness?
That's right, Judge.
And what would you like that witness to testify to?
Among other things, some additional tweets and truths from the defendant, as well as as a summary witness to go through some of the texts that were admitted as part of People's 171A. As you know, there was a lot of back and forth about that exhibit, about certain items that were redacted. We tabled it and agreed to have a summary witness read it later. I would like to address counsel's arguments from the bench, but also to address some additional arguments that counsel has made. And I don't think through any bad, but it's just not true. And counsel has said this several times, that counsel has not had notice of the exhibits that we are going to use. First of all, we have been designating exhibits for the last 8 months periodically on a rolling basis, and with very few exceptions, had designated all of our exhibits by March 15th. The court had a request from the people to extend, and you extended that deadline over the defendant's objection to March 25th, and we served a few additional exhibits. But it's not like this is the first time that these exhibits have been brought to counsel's attention. Second of all, before the trial started, we provided redacted versions of all of the exhibits we intended to introduce at trial, as well as an exhibit list. On April 11th, we had a lengthy conversation with counsel in which we listed precisely which Trump Organization-produced exhibits we would be seeking to introduce. And we did that because we were discussing a potential stipulation that didn't end up happening. But these exhibits have been designated for a very long time, so I don't think counsel is intentionally misleading the court to say that, they just found out yesterday that these exhibits were going to be admitted. What we have been doing is notifying counsel the day before who the next day's witnesses are going to be. The reason for this, as we've made clear, because the defendant has been violating the order, restricting extrajudicial speech. And we did not want to have the next witnesses' names out there. The defense has our witness list, has had it for months. That list includes Ms. Longstreet, who testified on Friday, and all of the witnesses who will be testifying at the trial. I'm saying this because I don't like the impression being left that we are somehow sandbagging the defense by telling them the day before who our witnesses are or what our exhibits are. They may not be finding out the order of which we're going to be calling these witnesses or introducing these exhibits. But they have had the entire witness list and the exhibit list for a very long time. Getting back to your Honor's question about Ms. Longstreet, we called her on Friday, as you remember, and let me just first say that, of course, the court has inherent authority to control the order and the mechanics of witness examination during the trial. As you know, we learned Thursday that a juror had a medical appointment or issue that required early departure on Friday. There were certain aspects of Ms. Longstreet's testimony that needed to come in before Hope Hicks could testify, and so we called her and truncated her direct examination so that we could get her off the stand and get Ms. Hicks on the stand so that we could hopefully finish her and not have to get her back today, because the juror had to leave. And as you recall, we timed that pretty closely. I think we ended on Friday at 3:30, and the juror had to leave sometime between 3:30 and 3:45. So shortly after, we discussed Ms. Longstreet. We put on the record at a bench conference that we intended to recall her. I don't think that there is any remote prejudice that the defense will suffer from allowing us to recall her for these limited purposes, which, as I said, include some additional tweets that were not relevant to Ms. Hicks' testimony, but are relevant to a subsequent witness testimony. And then to have, really, the bulk of her testimony will involve going through the exhibit that had been the subject of a lot of back and forth about which portions were appropriate to redact. And I believe at the time that we finalized that, we indicated that we would use a summary witness to read those texts.
Mr. Blanche.
Your Honor, I'm looking at the January 29th, 2024 witness list, and Ms. Longstreet is not on it. I'm happy to be told I'm wrong, but that's what I am referencing when I said that to the court, that I didn't have her name. Secondly, I did not say to the court at sidebar that we did not know the exhibits. I said we did not know which exhibits the people were going to offer with respect to this witness. She's not on it. And so the point was that when they told us included on the witness list was a custodian from the X Corp and a custodian from Truth Social. So when we learned that she was going to be testifying and getting those exhibits in, as Your Honor knows, we objected. And we prepared a cross based upon our understanding of what she was going to be allowed to admit. We didn't know, like I said, her name until Wednesday afternoon. We then performed the cross. assuming those were the exhibits she was going to offer. As the court is aware, part of the cross was that I think the point was that of the however many thousands of social media posts she was tasked with reviewing, the witness testified to only 7 or 9, whatever the numbers were that she was asked to identify and admitted in evidence. I did not know at the time, because no one told us what was just said today, was that there was timing and scheduling issues, and so they only intended to call this witness to get a few exhibits in, and then they intended to recall her. That's not the way it's supposed to work. And I agree with the people that it's absolutely within your discretion, under the rules, under Rule 107. But if you look at the cases, to the extent that there are cases on this issue, the reasons given for recalling a witness, at least that I have found, do not include a summary witness who they call just to get some stuff in, not tell anybody they're going to recall them, and then after the witness leaves the stand and say, oh, we're going to recall her.
Let me ask you, what's the prejudice to you?
The cross itself is the prejudice, Your Honor. We crossed the witness and said, and asked her about all, like I just said. It turns out that was totally wrong. It turns out that there are more exhibits that she was asked to offer and admit into evidence. And again, she's doing this as an employee of the district attorney's office, not as a custodian of X or Truth Social.
I'm not really following. If she takes the stand and she testifies as to additional tweets and truths, and it's a summary witness for dice to the defendant, Exhibit 171. What is the prejudice to the defendant?
The cross-examination of her on Friday included, in part, Your Honor, the fact that she was only being asked about 7 to 9 after reviewing thousands of social media posts by President Trump. And I believe she said, however, other folks, she said 10 or 15 other folks. The only evidence that the people had asked her to admit and to offer and to get into evidence were the 7 that were admitted. So it certainly doesn't help our defense that it turns out that there was a wrong amount. It turns out that there were other ones.
How many more are we talking about?
3.
3?
But, Your Honor, I'm not sure why that matters, Your Honor. Again.
Well, it matters.
She said that's all there was.
It matters that you are saying that there's prejudice, that somehow you look bad, that it's somehow she had looked at thousands and she only found 7. Now you are saying the prejudice is that it really wasn't the case. She's introducing more, but she's only introducing 3 more.
Judge, think about what we were just told, that they knew at the time, apparently on Friday, that they were only going to use this witness to get in enough exhibits to get them through Friday. If they would have said that to us, which they should have if that was their case, we could have adjusted our cross accordingly. Again, it matters. We don't have any idea who the witness is tomorrow. We still don't know. We found out about this witness, found out her name on Wednesday.
Right. When do you intend to call Ms. Longstreet?
Well, we could have done it this afternoon, but I think we should start with a new witness who we will. We have been, as a matter of courtesy. We were ordered not to provide counsel with the name of the witnesses for the next day until the next afternoon. I'll do so as soon as we are off the record. Give the name for the witness for tomorrow. I don't think we will get to Ms. Longstreet until Thursday or Friday.
All right. Well, I would like you to give the defense 24 hours notice before you call Ms. Longstreet.
We can do that.
So that they can prepare. And also let them know the exhibits which are be produced so that they can prepare their cross.
Thank you.
This video was brought to you by my supporters on Indiegogo. YouTube will not monetize these videos, so I can only afford to keep making them with your support. If you enjoyed this video and want to see more like it, please donate to my Indiegogo campaign so we can finish this trial. You can find the campaign linked at the top of the description or scan the QR code on screen now.